Well, hello, everyone. My name is Eli Yim. I'm an attorney here at Beresford Booth, working with the Business and Real Estate Group. And today, just a quick conversation about confidentiality agreements. The ins and outs of confidentiality agreements. I'm not sure there's so many ins and outs, but they are a critical piece of what we see in a variety of contexts, contractual contexts. And so we thought it would be worthwhile just to spend a few minutes here today talking about confidentiality agreements, and why they matter, and what kind of things you should pay attention to in this context. So thank you for joining us, and we will walk through these things together. Let's see if I can get my technical, there we go. So today we're going to discuss here the need for confidentiality. First of all, why it matters, why people are concerned, why we get requests in a different contexts for help with confidentiality provisions or agreements, what those key terms are that we want to include, and then kind of a thing that comes up quite a bit, and maybe you see it even in the context of the news or where people talk about confidentiality agreements or provisions, NDAs being unenforceable. Well, enforcement matters, and these things are enforceable. So we'll talk about that really briefly as a third point. So really, just to address some of those common misconceptions, I think sometimes we run into the issue where in a contract, people see it just as a standard term. Maybe there's a confidentiality clause or provision, and people don't really give it much thought until it becomes an issue. Like so many other things in a contractual context, things that people don't think that something is going to be a problem until it becomes a problem. And confidentiality provisions tend to be very important as a provision, or certainly in the context where it's a standalone agreement. So that's something that we don't see it as a throwaway term. It's a standard term, yes, but it can be critically important. And then I talked briefly about the enforceability issue. That's a common misconception that maybe they're not as enforceable, that it's difficult to enforce. And that's not necessarily true. You can try and mitigate some of that in the drafting process. So important, and important to do right. There are a lot of valid concerns and reasons why people insist on confidentiality provisions or agreements. Think of everything that you put into your business or your company and the need to protect it. A lot of damage can be done very quickly if you don't have the ability to maintain confidentiality and protect all of that equity that you've built in your company. So people have valid concerns around confidentiality, and as a provision or as an agreement, it's important to protect those interests. And so really there's two primary contexts that we see this a lot in. That is the business contracting process, and then also in employment agreements. And so we may talk about how those things are a little bit different as we go through some of these subsequent slides. One of the things I wanted to talk about early on, and it comes up from time to time with us, is, do you really want to do this, address confidentiality as a standalone agreement, or just as a provision or clause in the standard contract? And the answer is, it depends. It's not a very satisfying answer, but there's some considerations here. What is the nature of your business? How detailed do you need to get in your confidentiality language? The confidential information that you're seeking to protect, is it highly technical? Is it important that you break it down into certain components to make it more clearly communicated to the employee or to whichever other business you are contracting with. You know, what is the extent of the protection, and what terms do you intend to include to enforce those provisions? And so, you know, sometimes we'll see it, even in an employment context, we will do a separate confidentiality agreement if warranted, where we may have in the employment agreement itself, you know, a provision, a standard provision, and reference then the separate confidentiality agreement. Even in a closely held company, we can see that kind of a desire to be more detailed. And so it really depends on the client, whether it's a big company with a lot of IP, or whether it's a closely held company, whether it's an employment context or a business agreement. We can do it as standalone or as you know, a set of provisions within the contract itself. Really is going to be client driven there, although we would, you know, as we get to know our clients, we may have a perspective on that as well. I think part of it too is knowing who you're going into business with is part of the rationale there. You know, is this someone that you've worked with and had repeat business with over time? That may also warrant some consideration. The other thing I wanted to call out here at the outset is the timing issue. I think it is important to think about these things at the outset. Ideally, upon engagement, the parties have an agreement on what is confidential information, how are we going to handle confidentiality. You know, in an employment context, this can be important because, you know, arguably, if you were to negotiate some confidentiality provision midstream, so after employment has already been initiated, you know, it requires some consideration that something of value be exchanged here to make this an enforceable agreement or provision. So that's kind of taken care of with the offer of employment. To do something midstream may require some additional compensation or consideration. So that's something to think about in an employment context, but just in general, it's good practice to really think about these things at the outset of engagement and make sure that you've accounted for it in your contracting process. And so these are the kind of key terms that we would see in a standard CNDA or a confidentiality and non-disclosure agreement. Even in a context of a much more succinct set of provisions, we would probably touch on most of these things, just not in quite as much detail. Parties and purpose, obviously in a larger contract, that will be spelled out at several points throughout the document. But in a CNDA, you want to make it clear, like, who is going to be bound by this agreement, and really what is the purpose, what is the protection being sought, what is the agreement between the parties. So that's an important, you know, consideration just at the outset. Probably the most important piece of these considerations, the most important term, is where you define the confidential information itself. And it comes with a caveat, but you know, if we just think about in general how we might define confidential information, it may be business information, it may be financial information, maybe products and services, it may be IP, customer lists, databases, business methods, trade secrets, which is, we're not going to tackle trade secrets in and of itself here, but you know, that would be addressed within the context of confidentiality agreement. You know, even personal information we have drafted into certain confidentiality agreements to keep certain, whether it's access to, let's say in a closely held company or in a family business, someone comes to know or is going to have access to know personal information about family members, or in the context of an employer-employee relationship, that may be written in as well as part of the confidential information to be protected. And so really, when you look at the kind of breadth that you can see of confidential information, really taking it all the way from highly technical IP all the way to personal information, let's say in a closely held company, it behooves you to be as specific as you can be. The temptation is to cast a hugely wide net and cover as many things as possible. And in some ways, that can create more of a problem with some unintended consequences. So you cast such a wide net, it becomes overly broad. And now the court may look at that and say, that is so overly broad. I don't know how you could wrap your head around what exactly the confidential information is that should be protected here. It's not tailored to the situation, not tailored to the employment and the scope of work that the employee is doing, or it's not tailored to the information they have access to, or it's not tailored to the agreement between company A and supplier company B. So you really want to be thoughtful here and resist the temptation of casting too wide a net. It really should be customized to the relationship that is being established upon engagement. And so that is easier said than done. This is why I think one of the reasons why this piece, the term where you define as a defined term, confidential information, is so important, because you want to right size it and make it as appropriate as possible given the context. And so critically important that you do that, and both as far as coverage for your risk and enforceability on the back end. Now, this seems pretty straightforward then. After you spell out the confidential information, you want to, in express terms, explain that there is an agreement here to maintain confidentiality. Here you will see kind of a grant of authority to share confidential information with certain other employees or third parties or other agents in the service of doing whatever employment or whatever project is being contracted for. So in service of that, it's going to be necessary to disclose certain confidential information. And so there is some authorization here contractually that you'll want to spell out that grants that ability for the employee or for the company to disclose confidential information. So what are the contexts? And again, like I said a second ago, if there are other agents or employees, there's some coordination that needs to occur, then this is where that grant of authority comes in. Okay, so it's not a super complicated term. We tend to see this pretty straightforward, especially on the heels of this monstrous, oftentimes monstrous defining of confidential information. This grant of authority is important and understandable in this context. Now, there are certain exceptions that we will have, or we will see in confidentiality agreements where the disclosure or where certain information is not considered confidential, for example, or where disclosure may occur outside the scope of the agreement itself. So if there is information that is already publicly available, that is not considered confidential information. Or if it became available during the course of employment, or engagement, that is not confidential information. Sometimes one of the defenses is that the party to the agreement came into possession of this information from a third party, or developed something independent of any other confidential information. Those things are outside the scope of the agreement. And then, of course, kind of standard term that we see here is also that the party to this agreement, if they are required to disclose any confidential information in the context of some legal proceeding or under court order, then of course they're required to disclose the information. And so there are some, like I said, some exceptions here as to what constitutes confidential information. And so it's important that those things get spelled out. Don't always see that if this is a discrete clause in a much larger contract. We don't always see a lot of exceptions spelled out, but certainly we see those where there is a separate confidentiality agreement, just as we go into greater detail. The effective date and the length of obligation. Obviously, the effective date will matter. I guess the length of obligation is the more pressing concern when you consider drafting a confidentiality agreement or provision, because a lot of times you will see then where the obligation extends beyond the life of the contract itself. So the effective date is the effective date, but sometime you can write in and draft a continuing obligation beyond the life of the contract, where the party to this confidentiality agreement must maintain the confidentiality of the information over the course of a set number of years, usually defined here. Usually you don't see anything that is too long, but what is the right length of time to protect said confidential information? We can write it in here. It's a discussion we have with our clients. And we can certainly have that obligation extend beyond the life of the contract itself. And the next term that we would write in and draft, what do you do in the event of a breach? And you can think and put your litigator hat on and think about, if you were, as a client, engaged in an enforcement action, or if you needed to stop some disclosure of confidential information, what would you need to do? Well, you would want immediate relief. And so often you will write in here some injunctive relief, the ability to get an injunction to stop whatever release of confidential information is occurring as immediately as possible. And, bonds may be required for this. Certainly, either in an employment context or a contractual context between companies, a commercial engagement, termination, damages, sometimes liquidated damages, where you can seek a specified amount of damages, not necessarily as a penalty, but as damages that you anticipate arising as a result of the breach of the agreement. And then, of course, the other thing that you would want to include would be the return of any confidential information upon termination of the agreement. So, termination of employment or commercial engagement, injunctive relief with or without a bond required, damages or liquidated damages if we get to that level of detail, and then the return of all confidential information. And so that can all be written in here once we get past kind of what confidential information is. This clearly is the next section where you would scan the agreement and read, okay, we know what confidential information was, they breached it, now what can we do about it? This is critical that we get this part right-sized for the situation. And finally, miscellaneous. So here I was saying that we shouldn't talk about standard terms and just kind of gloss over them. Certainly we don't want to do that for confidentiality. And there is one thing in particular in kind of the additional terms that we would include within a confidentiality agreement that we would have in other contracts. And that here is, which law is going to be applicable and where is venue going to be. It's very important that that be part of the confidentiality agreement. Obviously, it would be addressed in a larger contract that we would have which law applies, the governing law, and venue, which courts will we be going to appearing in to seek relief. But it is critically important when it comes to confidentiality agreements that we make sure that, here we are in Washington, that Washington law applies and that we can seek relief immediately, for example, injunctive relief, in Washington courts or King County or Snohomish County. So we want to control that for sure here and be able to seek relief here in Washington if we can. The last piece is the enforcement piece. And I think if you do all of those things that we've talked about so far here and considered those different elements of a confidentiality agreement or confidentiality clauses, you should be in a good position on enforcement. Now, we've talked before earlier here today about being clear and being specific. Again, the more specific you can be in drafting the confidentiality clause or agreement, particularly around confidential information as a defined term, the better served you will be on the enforcement on the back end. If you do it at the outset, you consider the nature of your business, you communicate clearly with the contracting employee or with the contracting company, the commercial partner that you're engaged with, then this should kind of fall right into place, and there should be no concerns on the enforcement side. One thing, though, that I will say is you need to act promptly. It is critically important that when you do discover a breach of the confidentiality, that you act quickly, particularly in the context if a trade secret is involved. If you fail to protect confidential information, such as a trade secret, you may lose the ability to protect that same information going forward. It ceases to be confidential information. And so once you suspect or once you have documented that a breach of confidential information has occurred, you need to seek enforcement promptly. It's important not just to continue to hold the contracting party to the obligations that they agreed to, but even for future considerations, if you don't do it, you could lose the ability to enforce confidentiality provisions moving forward for that same information. And so that is the one real bugaboo, I think, for confidentiality enforcement that doesn't always get covered, but is an important consideration when we get to the enforcement piece. Well, I think that is really all we had today, just to kind of talk through the different considerations. Again, the context that we see these in more often than not are in an employment context, and in a commercial contracting, commercial agreement context. And they are enforceable. They can have teeth. I think too often we kind of hear, maybe it's kind of the noise from the news where, there's been talk of, can public employees be held to private non-disclosure agreements? Well, we're not in that sphere. So, but we have enforced confidentiality provisions in the past and held people to them, and you can imagine there can be quite a bit of value attached when you think of everything that is invested in a company and the confidential information that has been developed over time. You can imagine that there is some significant value and potentially some significant consequences. And so we want to make sure that those things are thought about and contracted for early at the outset, and that there's clear communication about it from the outset and maybe throughout the life of the contract, and that it is therefore no surprise that we can act promptly to enforce, if needed, any of those provisions. So that's pretty much it. But of course, if you have any questions, my email address and our phone number here at the firm is on the screen, and we'd be happy to talk through any questions or concerns that you may have about confidentiality agreements. Thanks for joining us, and have a great rest of your day.